Hi, everyone. I'm Maggie McGrath, senior editor at Forbes. According to the Associated Press and the Whistleblowers Association, an internal memo circulated among the ICE agency allowing ICE agents to enter people's homes without a judicial warrant. Joining us now is a lawyer who can talk to us about the legality of such a memo. She is Kate Lincoln-Goldfinch, an attorney, CEO, and founder of Lincoln-Goldfinch Law. Kate, thank you so much for being here.
Thanks for having me on.
So, as I noted, the Associated Press is reporting on this leaked internal memo where basically it seems to allow that immigration and customs enforcement agents can enter someone's home without a judicial warrant. Is this legal?
No, it is not legal. It's very clearly not legal. Administrative warrants are not judicial warrants. They don't go through the legal process that is required under the Fourth Amendment of the Constitution. There's a very clear prescribed process to protect people's rights in which a judge, usually a magistrate, will review evidence and decide whether a warrant to enter someone's home will be issued. And it's not until going through that process that law enforcement gets the permission or the approval to break into somebody's home or business. An administrative warrant is just paperwork, essentially, within ICE. It's an internal DHS or ICE piece of paper that says this person is on our list. And lots of people get placed on the list for lots of different reasons. And it is really concerning that ICE is behaving as if their administrative warrants give them permission to break into people's homes, and it is not legal.
So, just to maybe zoom out and clarify for folks watching, in a normal constitutionally legal scenario, if a federal agent is approaching their home with a warrant, 9 times out of 10, 10 times out of 10, that is a judicial warrant. It's not an administrative warrant, as you were just describing.
Well, historically, a judicial warrant is what we would see law enforcement come with to somebody's home. What's happened in the last year is that the Trump administration uploaded almost 1 million administrative warrants into the national database. It's called NCIC, and this is the criminal database that all criminal agencies use when they run somebody through their system. So unfortunately, many of these administrative warrants were created and then were shared with law enforcement. So that has created a fair bit of confusion and shifting policies amongst various law enforcement agencies. If you think about each state and locality probably has a local police department, a state trooper, a county sheriff, and each of these agencies now has to grapple with what is an administrative warrant? What does it look like? What information supports it? What do we do with these? Do we contact ICE? And so it's created a lot of instances, not only where ICE itself is creating its own warrants based on whatever evidence it wants and then going out and going into people's homes, but it's also sharing all of this information with other law enforcement agencies, most of whom weren't prepared and haven't known what to do with it.
Now, the memo says in part, and I'm quoting here from what the Associated Press was reporting, although the U.S. Department of Homeland Security has not historically relied on administrative warrants alone to arrest aliens subject to final orders of removal in their place of residence, the DHS Office of the General Counsel has recently determined that the U.S. Constitution, the Immigration and Nationality Act, and the immigration regulations do not prohibit relying on administrative warrants for this purpose. End quote. So there's some legalese in here, but let's kind of zoom out for a second. The Constitution, immigration law, nationality law, those three entities were cited in that quote that I just read. How does that justification strike you as a lawyer when you hear that argument?
It's very flimsy justification. First of all, the Constitution says otherwise, and there is a very robust and lengthy body of case law in the United States from the Supreme Court, which talks specifically about people's rights. I mean, when people's liberty is at stake in the criminal justice system, there's just a lot of rules and protections and due process and case law about this. So for one memo to just all of a sudden claim that the Fourth Amendment doesn't apply, it says other than what it says, and we're changing the way that the law has been applied within the court system with a secret memo just doesn't fly, and it won't in court when this ultimately gets to court. But this is behavior that we've seen from this administration where they want the law to be different, they want the application of the law to be different, or even facts to be different, and so they'll just state it both in executive actions and in memos and in press conferences. And it's incumbent upon all of us, is residents of this country, to pause for a moment and understand that just because they say something in a memo doesn't make it true.
And the language in that quote that I just read was interesting because it was a bit of a double negative. It does not prohibit. So, which to me legally feels like a different argument than saying explicitly allows. Is there some clever wording at play here?
Probably so. And what I think we've seen multiple times now with this administration is that it will create an interpretation that probably somebody within the agency understands as illegal, but they'll state a policy and then they'll enact a policy and they'll wait until they get stopped by the courts. And this is what happens over and over again, particularly in immigration, which I've seen this in my field so many times, where they're out there on the streets doing something they're not allowed to do that is unconstitutional or illegal. But we have to collect instances, bring lawsuits, obtain federal court orders, and then ride those orders up through the appellate process, through the circuit courts, maybe all the way up to the Supreme Court. And it can take, in my experience in the last year, 3 to 4 months from the moment the administration says it can do something illegal, starts doing the illegal thing, and then the courts stop them. We've got a good 3, 4 months of them engaging in this illegal activity before the courts can step in. And so that's the big concern here, is that not only has this already been going on since about May, it appears that this will continue until the courts can step in. And that's a multiple months long period of time. And so in the meantime, what do we, the American public, do to protect ourselves? That's a really difficult thing to plan and prepare for when you know that they might break down your door at any minute based on some piece of paper that they've created within their own system that has no judicial oversight process. And if you have law enforcement breaking down your door without a warrant, you can't really safely protect yourself. So what do you do instead? And we're just back to, we have to create evidence of all of this illegal behavior so that hopefully justice can come later. That's the point that we're in America right now, and it's really, really scary.
So the point we're in right now in America is the collecting of evidence. So are there any cases, any lawsuits in the courts right now that are on that 3 to 4 month timeline, or is there no litigation as far as you're aware?
I'm not personally aware of any litigation, or I'm not involved in litigation, I should say, but this memo will be very helpful in these lawsuits. So for the people who have had ICE come into their home or the private area of their business without a warrant, it's really important that you pursue justice, especially if you have film, evidence of what happened, because now that we have this memo, we know that this is how they've trained their officers since May of last year. All of these new, obviously untrained or poorly trained ICE and CBP agents who are out on the street violating people's rights and breaking into their homes have been trained based on this memo. And we know that now. And so people do really need to be pursuing justice. And that means finding a lawyer, talking to a lawyer. I know that there are a lot of impact litigators, a lot of nonprofit legal service providers who are taking these cases. And so just because you may not be able to afford a lawyer or you don't know who to call, reach out to someone because I know of a lot of good lawyers out there in the world who will take these cases.
Now, you mentioned you are an immigration lawyer. You are based in Texas. I'm wondering, Kate, what are you hearing from your community, and what are the questions that your firm has been fielding the most this year, or even since this memo was uncovered, or since May of last year?
I think the most heartbreaking thing is that the number one question I get from people is how to protect their kids and how to keep their kids from being taken from them. And it's a legitimate concern. So my number one piece of advice to immigrant families where one or both of the parents doesn't have a green card or citizenship is to create a family plan and to have a caregiver authorization for someone who can come and get the kids quickly if either parent is being picked up. Because if not, those kids might be placed into the state foster care system, and it might be a battle just to get the children reunited with their parents. And I've worked on reunification cases. It is hard. It is hard to get these kids back to their parents. And so the number one thing I think parents need to do is think through how to protect their children, because the threat is very real.
And going back to where we started this conversation with the difference between a judicial warrant versus an administrative warrant, if someone is presented with an administrative warrant, if agents come to their home and present a warrant that is not a judicial one, what would you tell that person in this hypothetical situation?
Do not open the door unless you see a judicial warrant that is signed by a judge. And they can be difficult to identify, but what you're looking for is the name of a federal court, like the Western District of Texas, and a signature from an actual judge. An ICE warrant is a piece of paper. It's often Form I-205, and it'll say something like the Department of Homeland Security. So it'll say an agency versus a court. You can ask them to show you this piece of paper that they have through the window or slide it under the door, and do not open the door unless they have a judicial warrant that is signed by a judge. If they break down your door, it is safest and best to comply and cooperate and not to resist. And we've seen what happens when people resist arrest. But I also think it's very useful for us to record with our phones when we can, but also set up both our cars and our homes with automatic recording devices, like a dash cam or some type of camera, a doorbell camera that will automatically record, date, time, audio. So all of that is already being done for you if you can't reach your phone. And again, we know that we have to just not get aggressive. Another thing that I think is really important is that we know that the Trump administration is itching to use the Insurrection Act against the American people. And so what they're looking for is for some protester or some detainee to get violent with them so that they can justify calling out the military and bringing the military against the American people. So all of us need to understand and not give that moment to them and not get violent, as distressing as it is to be in a situation where our rights are being violated.
We've covered a lot of ground as it relates to this specific memo, and I know there's been a lot of other news swirling around ICE and its activities this month. But for the sake of keeping this conversation focused, Kate, is there anything else we should know, that the Forbes audience should know about this memo, about constitutional law as it relates to searches by federal agents with a warrant?
I know that oftentimes we think about what else can I do? And sometimes hearing call your legislators feels like it's not getting anywhere. What I want to say is when we're concerned about our constitutional rights being violated by our very own law enforcement, we do need to be contacting our legislators. You can contact your congressperson, you can contact your senator, and you can tell them that you are a constituent and you are worried about what is going on. And you need Congress to stand up for you and your own constitutional rights. These calls do get tallied and they do matter, and public opinion matters. So also Share this video. Talk to the people that you think aren't aware of what's going on, the ones who aren't chronically online because they're protecting their mental health. Make a phone call to 5 people and have them call 5 people. We need to get the word out about what's happening, and it's up to us, those that are paying attention, to make sure the ones that aren't paying attention start to be aware.
Kate Lincoln-Goldfinch, immigration attorney and CEO of Lincoln-Goldfinch Law. Thank you so much for joining us and sharing your analysis and insight. We really appreciate your time.
You're welcome.